Mr. Hopkins. Mr. Hopkins. Yeah. No, over here.
You're Mr. Terrell Hopkins?
Yes, sir.
Yeah, here in cause 22-39026. There's a motion to revoke unadjudicated probation for unlawful possession of a firearm by a felon. You were placed on 10 years deferred of unadjudicated probation a few years ago now. This is going on 4 years. Anyway, this states they filed this because you failed to report to the probation office. This states on or about October 21st, the year was 20,225. We got to fix that. Did I miss something or did a few years pass?
Yes.
Okay. And then November 3rd of 2025, which was more or less realistic, December, January. So you were missing these monthly and you weren't reporting, which is the most important thing to do is to report, or else you're not on supervision, which is what this is all about. And people think that's not important, but it is the most important thing. There's nothing we can do to help fix this mess that you got yourself into because of your inattendance. I'm looking at a 1988 robbery conviction in Michigan. Then you have the illegal possession of a firearm, and it states that you have that conviction out of another conviction out of Oakland County for illegal possession of a controlled substance back in 2010. So you've got that 88 robbery, then the 2010, and then now this new charge, which is a third-degree felony in paragraph 1. But because of paragraph 2, that robbery conviction, the way they pled it, this third-degree felony is enhanced to a second-degree felony. So you're looking at up to 20 years in prison if convicted. All right. And you're not eligible for probation in front of a jury if you try this. So where are we on this?
Just where we were, I know the offer was 4 years, but I believe we came to court on the 1st, and I think the motion to revoke hadn't been filed yet, and I think you reduced his bond to $10,000 because he reduced the bond, and I believe the state has filed a motion to revoke. What you said on 3rd, right? 3rd or 4th.
Yes, this was filed on June 3rd.
It was filed on June 3rd after our court date on the 1st. So I guess where I am with him right now, Judge, is
what would you like to do today? It's early. What? He's sitting in jail. This ought to be something y'all might be able to work out, but maybe not. I don't know. I just want to give you a few weeks to do that.
That's perfect. We'll try to put it together.
2 weeks good?
Perfect.
Yeah, okay. Let's see where we are, sir.
Okay.
Sir?
Personal crimes bonds?
No, sir. Not when you're looking at this. These multiple charges from the past and now. And you're looking at the failing to report.
I reported the arm.
This, the state says you didn't on October 21st, November 3rd, December 5th, January 6th, which their monthly report.
I was in a rehab. She knows this.
Well, it's not, this isn't the hearing on the debate.
Yeah. Sorry.
Judge, it was my understanding from speaking with probation that he was ordered to go to safety after the administrative hearing and then did not report to safety, which is why we went ahead and filed the MTRP.
That what happened?
Yes.
Okay. Why didn't you report to safety?
Because I take certain, like I was telling you, and then she told me it was 6 months to go to St. Pete, right? And then I was informed that because you take that medication, you can't just do 6 months. You would have to do 6.
Who told you that? Who told you about the medication?
Everybody knows this.
Everybody?
They says.
Oh, these people are giving
You do 9 months of
medical
CP.
advice to you who you don't know?
It's a law that you got.
I know what the law is.
It's 9 months of St. Pete plus
Oh,
3 months.
I know all of this.
Plus 3 months and a half warehouse.
Now, I know that, here's the problem, once again, is you failed to report, which is the most important thing to do. That's what this states, and that's what this hearing is going to be all about, is your failure to report on all these months. That's since October. I mean, you were essentially, we call that an abscondence. You were on your own probation, which really shouldn't be. You're supposed to be supervised. And if you don't report, you can't be supervised. It's the most important thing. That's why it's always, I mean, in your probation order, you remember receiving that. Report is directed right at the top. You're supposed to report at least every month. And we had to go find you somewhere. And that's what this hearing is all about. When can you do it? All right.
Thank you, Judge.
Jesse Mason.
Yes, you should be right up.
What's going on this one?
This is so all right. The rest of that big please,
I'm sorry.
so the rest of the cases will be please,
Jesse Mason?
Mason.
Yeah, Jesse. Thank you.
He's being the
Is
bailiff.
Langston, being a bailiff today, too?
Yeah. He's in.
Is he doing that for some extra bucks?
Could be.
Is that a supplemental income? Look at it. Just like the bailiff. Thank you. Good work. Kendall, relax. Langston's doing all the bailiff duties, right?
Not bad, Hey.
It's taking over. That's right. Are you Jesse Mason, sir?
Yes, sir.
In 26 CR 446? Hello. Okay. You're charged with the state jail felony of unauthorized absence from a community correction facility. Was this one of those things where he was released for visitation or something? And since left the center as intensity of knowingly leave said center as directed by the court and the community supervisor and without the conscious approval of second order. Right. Once it's been in there while he was required as a condition of community supervision. Required as a condition of community supervision, required as a condition of correctional programming. I know that makes sense. To submit to a period of detention and treatment in a community correctional facility, namely Beaumont Center. And you intentionally or knowingly left said center as directed by the court and the community supervision correctional. That doesn't make any sense. And without the approval. So it says that he intentionally or knowingly left said center.
Judge, I
As
agree that
directed. I'm just reading the indictment.
yes, I agree that the wording is interesting and the facts on this are a bit unique. I believe that the indictment is alleging that he was supposed to be in the center as directed by the court and community supervision, and without approval of the court and community supervision, he left the center.
Well, it says that's not the way it reads.
Yes,
Says
we can,
intentionally or knowingly leave said center as directed by the court. I didn't direct him to leave.
no, Judge, we can get that fixed.
Yeah, the wording's bad on this, sir. We're trying to, first thing is, it doesn't matter until the indictment is fixed. That's the most important thing. Everything flows down from the allegation. And the allegations, it's alleging up at the unauthorized absence, but the body is confusing and it needs to get cleared.
Yes, Judge, we will go right on that.
The thing is, you've got those 3 prior convictions in January of 22 for out of Gregg County, which are terrible things. this is a state jail felony, but if all of these three convictions are true and you're convicted of the correct wording that was intended based upon the offense as alleged, then this would be a state jail felony, though punished as though it would be a third degree felony. It gets enhanced one level because of the three prior convictions. And the thing that helps you on that is that these were three convictions on the same date, so you can't stack them because they weren't in sequence of dates. But it's still a state jail felony punished as a third degree felony, so you're looking at up to 10 years in prison, which is never a good thing, and you're not eligible for probation in front of a jury because these allegations of prior convictions are in the indictment, and if one or more of them were true, that wipes out a probation qualification for you in front of a jury. So that's what I think we're looking at, right, Don?
Yes, Judge.
Okay. She needs to repair the indictment.
Yes,
Can you do that in 1 week?
we can try, Judge.
Well,
I'll get it to intake today, but
thank you.
Judge, he's also asking that regardless, it'd be set for trial, that I'd be relieved to get to court with him.
You be relieved for what?
That I'd be relieved.
So he can be pro se?
No, sir. He wants another attorney appointed, so it can be resolved
No.
with a matter.
Don Dusler, I've known Don Dusler my whole career. He's a fine lawyer. You can go hire anybody you want, but I chose him as one of my public defenders because he's competent and he represents his clients. I've known him for 4 years. And but you can hire anybody you want, but you don't get to pick the appointed attorneys. That's not the way it is, sir. Sir, go ahead.
I am requesting another one.
Okay, you're denied. Denied. You are entitled to a competent attorney, and he is one. I haven't heard anything to suggest he's otherwise, or that there's a problem between y'all two. That's the way it works. You can understand if it was otherwise, let's say we have 3 public defenders or 4, and then everybody decides they don't like 3 of them, then one person would end up doing 1,000 cases. That wouldn't work. But they rotate. And sometimes you may disagree with them, but I was a lawyer, private lawyer for a long time. And sometimes people didn't agree with the advice I was giving. But you're entitled to know from legal expertise what you're facing, the pros and cons. At the end of the day, it's not his choice, it's your choice on how you proceed, but you don't get to choose the attorney when it's an attorney that's appointed to represent you if the attorney didn't do anything inappropriate or unethical. Don doesn't do that. So he has a good reputation. Let me just rotate this a week so we know where everybody stands on what the defendant wants to do.
yes, Judge. We'll get that indictment.
This needs to be, you can correct it.
It'll likely have to be re-indicted
Yeah, well, that's what they do on Thursdays. Right?
Wednesdays. Yes.
I see.
Yeah.
Okay.
I'll do that
And
today.
We'll do this back on Monday week and see where we are on that, okay? And see if there's a way that can be resolved without a trial, and then if he wants a trial, he'll get a trial, and then it's one of the trial lawyers.
Can I speak?
It would be different from him. Yeah, you can speak.
Your Honor, when I arrived at the police station to turn myself in because I realized I had made a mistake, I learned that the blue warrant had not been active yet.
Okay, hold on.
And
You're talking about the facts of the case, right?
To the halfway house.
Yeah, hold on. You're talking about the facts of the case. And number one, unless you're going to ask me to be the judge and the jury, you're going to have a jury trial if you want a jury trial. But right now you're talking about facts of the case, and I'm not the fact finder for whether you committed a crime or not. That's not what we're here for today.
I was just trying to tell you.
There's nothing I can do about change.
Arrested.
Okay, sir, there's nothing I can do
They didn't
about it.
read me my Miranda rights.
Okay, all right, that's something you tell your lawyer, and that's brought up in front of the court or the jury if that isn't part of the element of the crime. But that's not anything that really I can do right now. But that's where you pass all that, then that gets brought up during a trial or doing a pre-trial hearing, and then the court or a jury would make the fact issue determination, and then your life proceeds in that direction. But right now, that's not there's nothing I can really do about what you're saying. First thing is the indictment needs to get corrected.
Yes, Judge.
That it's,
Get on that.
it's clear. Okay, and then I'll reset 1 week and see where we have gone from there. Okay, sir? Don, thank you. Don, I've got Sergio Preciado, that's reset.
It's been reset. We'll wait for an interpreter.
And that's where today's hearing ends. Not with final verdict, but with more questions and answers. The indictment needs fixing. Attorneys are preparing their next moves, and the defendant still has major legal hurdles ahead. What do you think? Was the judge being fair by focusing strictly on procedure? Or should he have given more weight to the defendant's explanations? Let us know your thoughts in the comments. And don't forget to subscribe for more real courtroom breakdowns.